Good afternoon, AP Government class. I have missed you. Hope you're all doing well. It was great to check in with you on Wednesday. I want to finish up the Chapter 4, Chapter 5, Civil Liberties and Civil Rights PowerPoint. I had the first half of the discussion last week, and I just want to finish up with the second half of this PowerPoint, just giving you a little bit extra information, hopefully clarify some of the issues that you encountered. If you ever have any questions, please feel free to email, or you can leave a comment in the comment section so that I can return your question or comment in any way that I can. So on last week's teacher discussion, I was mainly focusing on civil liberties. So the Bill of Rights is not exactly given the correct name. So they say that they're rights, but in fact they are your liberties, your protections, so that you have freedom to express these rights. And so I just want to go through after the First Amendment, which is what we focused on last week. There are just these other 9 Bill of Rights, the first 10 amendments. So the Second Amendment, right to bear arms, it's pretty self-explanatory. Third Amendment, which is not usually known, the no quartering of soldiers during peacetime. And that was created mainly because it was an issue leading up to the American Revolution. It has not really been an issue at all. In fact, the last Supreme Court case that even touched on the Third Amendment was like back in 1982, talking about the National Guard and how soldiers would be treated in the times of peace rather than in times of war. So that's not really a major issue of concern. The amendments for 4 through 8 are known as your rights of the accused. Essentially, what are your protections? So no unreasonable search and seizure for 4th Amendment, 5th Amendment. There's a bunch of different rights that are associated here. You cannot give up your incrimination, or you plead the 5th when you say that you have the right to remain silent. You do not have to share information. It is not your job to prove that you are innocent in a criminal justice case. It is the criminal justice system that needs to prove you are guilty. So you do not have to share any information whatsoever. That is your right under the 5th Amendment. You also have the right to a grand jury. You cannot be tried twice for the same crime, no double jeopardy, and you cannot be deprived your life, liberty, or property without due process. So your due process rights, essentially. 6th Amendment, you have a right to a speedy public trial by jury. Also, you are to be informed of your charges, confront witnesses against you. So that's part of your Miranda rights. You have the right to an attorney. You have if you cannot afford an attorney, will be provided to you free of cost. So that is part of your Miranda rights. That's the 6th Amendment. 7th Amendment, right to a jury if you are suing for over $20. So essentially civil trials. Civil trials are your right under the 7th Amendment. 8th Amendment, no excessive bail or cruel and unusual punishments. 9th Amendment, just because the Constitution doesn't say you have a right, that does not limit what your rights are. So it's not only things that are found in the Bill of Rights and the amendments to the Constitution. You have other rights as well. And then finally, the 10th Amendment. If there's not a right specifically granted by the federal government, then the states have the power to reserve those rights. So essentially, if the federal government does not take responsibility for something, an institution or a legislation, regulation, then it's the state's responsibility to protect those for you. I'm going to skip that next part because it's a group activity, and since we're not in school, it's going to be kind of pointless to do those group activities. Let's move on to civil rights. Now, I mentioned already that civil liberties and civil rights are not the same thing. So civil rights are making sure the government steps in to protect you against your being discriminated against, if you're having your rights taken away from you. So it is the government's responsibility to protect your freedoms. The Bill of Rights applied to the national government. They typically were involved in a case-by-case basis. It is also referred to as selective incorporation. I'm going to pause because I'm receiving a phone call. Give me one moment, everybody. Sorry about that, guys. I received an important phone call, and now I'm done. And now we can get back to where we left off. We were talking about selective incorporation. So basically, the Bill of Rights is handled mainly on a case-by-case basis. Courts are requiring the states to follow the provisions of the first 8 amendments. When we talk about civil rights, we're talking about groups that face discrimination, mainly because of prejudice, because of viewpoints. These are guaranteed within the Equal Protection Clause of the 14th Amendment, and you see most civil rights cases dealing with the 14th Amendment. They typically are much more controversial in nature than your selective incorporation of your civil liberties. So civil rights, again, are protections granted by the government to prevent discrimination against certain groups, whereas civil liberties are protections of individuals against government action. So make sure that you have the difference there. So when you're dealing with a civil right, claims are raised when a group is denied access to facilities, to opportunities, to services available that are already available with other groups. So discriminations against specific groups, and when that's violated. Protected class. People protected from discrimination are typically minorities. When we talk about minorities, we're talking about people that are not the majority in a situation. I know that sounds pretty self-explanatory, but minorities can be many different makeups. It is not simply ethnic minorities that we're referring to. We're not just referring to race. You can refer to sex with men versus women. So women would be a protected class as a minority in the working class, at least. People over the age of 40 age can be a type of discrimination, age discrimination. And I know that you've seen age discrimination for people that are underage. People under the age of 18 have been discriminated against in many forms. So protected classes are any specific group that you are focusing on. Disabled Americans, handicapped, so physically, mentally handicapped individuals would be seen as a protected class. So what do all of these groups have in common? The main issue is that they have been discriminated against in some way, shape, or form within society. There's a historical discrimination, and so actions taken through civil rights cases are going to try to overcome that discriminatory practice. Take a look at the civil rights movement in the 1950s and the 1960s. So mainly we're looking at a racial discrimination against African Americans. What was taking place in the civil rights era was groups such as the National Association for the Advancement of Colored People, the NAACP, went through the court system, mainly looking at how you could challenge actions that were taken against individuals or groups. The first major successful Supreme Court case would have been for education to be equal, it must be equally available. So this, before the Brown versus Board of Education decision, you have a number of decisions, the Gaines, the Sipple cases that are talking about making sure education is equally available to people. Then that next step in the process was making sure that racial barriers did not create unequal educational opportunities in those, the Sweat and McLaurin cases. And then finally, the one that you're most familiar with the Brown versus Board of Education decision, that these educational facilities are inherently unequal. So it was a step process. It was not simply a 100% we're going to change the current narrative of discrimination. It's making legal decisions on what defines unequal, or what is seen as unequal, and trying to remove those inequalities within society. And so the NAACP took this step process rather than simply going all out with the Brown decision. What Brown is going to really be a landmark for is discussing that not just in education, but basically all areas of society, you see that facilities are unequal, that access to educational opportunities in this respect, but like access in transportation, access in um, technologies that are available. Other districts had gone out of their way to create equally funded schools, whereas Topeka, Kansas, the one that this case is focusing specifically on, made sure that there was inherent inequalities that were already available. So this was a unanimous court opinion. It determined that segregation was detrimental, that it created a sense of inferiority in African American students. There was actually a psychological study that was done around the same time period, and it was used in the Supreme Court decision that the case study had a number of elementary age students play with dolls, and they were given the option of using either a white doll or a African American doll. And in the case of pretty much every student that was researched here that had this study, both African Americans and white students chose the white doll. And the question for many of the African American students choosing the white doll, why did they choose that doll? And their response was because they said it was better. Now, they weren't prompted in that way. They simply, based on their experiences, were inherently trained that white people were better than black people. And even at such a young age as 5 or 6 years old, you have students choosing white dolls over black dolls because of that ingraining within society of the inherent inequalities that existed. So this was kind of the nail in the coffin for segregation for the Supreme Court. This was a unanimous opinion, and this was not recognized as like the moral decision that all Americans believed in. There was a huge violent backlash in the South, resistance to this court decision. Desegregation, which is trying to end the segregation that existed, was ignored by many people in the South. There was massive resistance. And you can see this is kind of a history lesson here on what happened during the Civil Rights Movement. You have all of these examples of trying to push for desegregation and the pushback that Southern society had. The Southern Manifesto was in response to the Brown versus Board decision, saying that their way of life should not be pushed upon them, that this is a cultural matter, and that if it worked for generations, it can continue to work. So there's this ideological pushback in what was going on in the South. You have the various groups like the Southern Christian Leadership Conference and the Student Nonviolent Coordinating Committee that are going to push for nonviolent civil disobedience, testing whether the Supreme Court is going to protect these newfound freedoms, that the law enforcement would be involved, that the federal government would step in if necessary if states weren't willing to protect African Americans. And you have a number of examples of this nonviolent civil disobedience that was championed by Gandhi during the rights movement in India. So you have the Montgomery bus boycott. We talked about this last year. Montgomery bus boycott, the Little Rock desegregation crisis, Freedom Riders, sit-ins at lunch counters. And then you have pushback against these actions with white resistance. Birmingham was referred to as Bombingham for a number of years because of the pushback against these civil rights actions that were taking place. You have the March on Washington. That is kind of the seminal moment of the civil rights movement, when you have all of the leaders of the various organizations pushing for an end to segregation, finally speaking out in a federal national way. So this was a long process. What changed because of the civil rights movement? Well, public opinion, first and foremost. Television has become much more common and showing how one side is using nonviolent means, the other is using hate, violent intimidation tactics. It was pretty apparent to most Americans, especially in the North, that the actions of Southern segregationists were kind of they were not showing their superiority with the way that they were treating the situation. So a lot of moral high ground was focused upon when you have on television the nonviolent actions of the civil rights advocates. A lot more young college-educated people are going to be involved in the process. Most of the actions of the 1960s when it comes to civil rights movement were performed by high school and college students. So people your own age were actively involved in this process. And you can see that with movements even to this day, where a lot of movement like the Me Too movement and with gun rights advocates, people pushing for the end of violence, with all of these actions, especially in the last couple of years with school shootings, you saw a lot of high school and college age students taking the lead in protesting the government and its actions. I'm going to skip ahead here. Civil Rights Act of 1964 is probably the most important legislation that has taken place for civil rights during not only this era, but all of American history, really. The Civil Rights Act of 1964 is going to be very comprehensive, prohibiting discrimination in all public places, in all schools, in the workplace, in voting accommodations, public accommodations as a whole, like public transportation. It creates the Equal Employment Opportunity Commission that provides job opportunities and getting rid of racial discriminations, gender discriminations, age discriminations in the workplace. Those that fail to follow through with the Civil Rights Act are defunded by the federal government. So a lot of federal funding is dependent upon compliance with the Civil Rights Act. It also allows the Justice Department to step in when discriminations take place. Most recently, we saw a few years ago, there was a question about transgender bathrooms in schools and high schools. And in this area, mainly there was a focal point in North Carolina because the schools of North Carolina said that they refused to provide bathrooms and said that people that were biologically born, male or female, had to use those corresponding bathrooms. This became a national issue, and we're still kind of dealing with the ramifications of that today, which is why we've provided at Port Byron the bathroom opportunities for I guess they're called neutral bathrooms, the bathrooms that are right next to the boys and girls bathroom that anyone has access to. I'm going to skip ahead here. These are various court cases that deal with civil rights, but I'm going to focus on gender-based discrimination. So one of the readings that I had to do this week was Have Women Achieved Equality? And so this is a contentious issue. If we were in class right now, I'm sure we would have a very spirited debate on access to employment and educational opportunities for women compared to men. So the main issues that surrounded gender-based discrimination were access for women in areas of society, in public areas of society. Jobs, essentially. Jobs and education. And we've talked kind of like about sports for women. Title IX allowing for So women's participation in sports, in the workforce, that kind of stuff. Sexual harassment. This is an area, especially in the 90s and the early 2000s. The Me Too movement is kind of indicative of sexual harassment, not only in the workplace, but in general. So, quid pro quo, I know that is a famous phrase that was used during the impeachment process. Basically, it is a Latin term that means this for that. With respect to sexual harassment, quid pro quo is referring to sexual favors as a condition for holding a job, for promotion, or having access to something in exchange for another action. This for that. Hostile environments in the classroom, in the workplace, in general, creating a setting in which harassment impairs a person's ability to work. Um, Employers are liable if they are negligent. Schools are liable if they do not take any sexual harassment claims seriously. All actions need to be investigated, whether it is through adults, whether it's through students. These are all, in any situation, they are handled with seriousness, that they are not going to be just pushed aside. It is the government's job, it is the institution's responsibility, according to the laws of civil rights in our country, that they must be investigated if there is a claim made. Harassment, either verbal harassment or physical harassment, is not kind of, one is not seen as less extreme than the other. They are both considered to be illegal forms of harassment. The last group that I'm going to be focusing attention on when it comes to civil rights law is Americans with disabilities. So, physical, mental disabilities. It really is not until very close to your lifetime in 1990. So, your parents were in school or they were out of school at that point. I don't know how old your parents are. I'm assuming your parents are around my age, so that means they were already in school. I was 8 years old when the Americans with Disabilities Act was passed. So, for all of American history up to that point, there were no accommodations made for students with special needs or Americans with physical or mental handicaps that were not providing them equal access to job opportunities, to employment opportunities. I just said the same thing twice. Just to give you like a little personal antidote, in my first years in elementary school, there was a separation of students. If you had a physical or a mental handicap, if you were identified as having special needs in school, there were actually separate schools that were created specifically for students with special needs. There were no special ed classrooms. There was no integration of students within the same classroom. They were literally separate schools that were created for either physically or mentally handicapped individuals. The American with Disabilities Act is going to remove that. It's going to require all accommodations being made for people that were disabled. So this came to the issue of what is actually constituting a disability. So in New York State, we call people with either physical or mental handicaps, we use special needs as the correct term, the politically correct term. And it might surprise you that your class, AP Government, is considered a class of special needs, that people in the advanced placement program, college level students in high school, is seen as a gifted and talented special need. And so you would fall under this form of education law, that you would be seen as somebody, not necessarily a disability, but you would be seen as somebody with a special need. So it really kind of comes down to how you process what is considered a need. Well, according to the Americans with Disabilities Act, anybody that is not able to perform at what is considered a normal level. So, what is normal? I Can't really give you the answer to that question because it is not defined by law what is considered normal. There are various levels of mental and physical normalcy that it really kind of depends on the local district, the local community, what is considered normal. And then also, what is considered reasonable accommodation? That is also a question that is not really adhered to. And that's where I'm going to leave you. I'm all set. I hope this was helpful in some way. If you have any questions, please email or make sure that you leave a comment. I will talk to you again next week.